Page 22. Robert Ronchi, 22 CR 006320.
Your Honor, there was an email from Leslie Clements, the JEA, that says the attorney Robert Draskovich was running late. He wouldn't be here until 9:45. It's 10:02 now. I just asked if the court will allow a trail to the 10 o'clock. I'll stick around. If he shows up, great, and if not, we'll ask for a warrant.
All right, that'll be the order.
Thank you.
We'll go ahead and trail that.
Mr. Draskovich.
Yes.
Okay. Judge, page 22. Robert Ronchi, 22 CR 006320.
Good morning, Robert Draskovich, on behalf of Mr. Ronchi, who is present at liberty.
All right. And we're on calendar for the non-compliance report this morning?
That's correct, Your Honor.
All right. Is it resolved?
It's not, Your Honor.
Okay.
Your Honor, it looks like in this case we have a jury trial that's scheduled for March 21st. Based on the report's dated January 12th. According to the report, the victim in this case came into special programs, came into contact with them, and reported that the defendant had been having contact with her. Now, I'll clarify that it looks like, based on the report, and speaking to Mr. Sibbett here from special programs, the defendant was allowed, because of family court, to have contact with the victim.
Alex here. I'm going to talk about repeated issues that I keep seeing with certain family division judges disregarding what's going on in the criminal proceedings later on in this series. I usually do not provide commentary, but there is a rare exception that I've used in the past and will use in this series when a district court judge vacates upcoming hearings and there's a bunch of complex substantive issues that were not covered by video. That hasn't quite come up yet. We still have to publish part 3 of the financial trial. But after that, there were 2 very substantive hearings that popped up that the family court vacated. So at that point in time, I'll go ahead and loop in some of my discussion on this issue.
But the purpose of the contact was to be about the children. And my understanding is that they have 3 children. They're all not of age, and that there would be a need to have contact about the children. However, it looks like, based on the violation report that we have, the defendant sometime in December sent a text, which are attached to the report, that didn't really have any bearing on any of the needs of the children. So they're really unnecessary. There's no reason to contact the victim in this case for those purposes. And then also, it's not listed in the report, but there is also a victim statement or witness statement that's attached to the packet. It's authored by the victim in this case, and it says that he did attempt to contact her on January 4th. He called the cell phone of the victim. She didn't pick up because she was scared. And since then, he's messaged her multiple times, trying to get her to talk to him on the phone. She told him in a message that he should only text and only about the children. And then she says that he insists we need to talk on the phone, and that she was being unfriendly, and that's in quotation marks. And she's asked him to communicate via text messages. So I think the purpose, it doesn't say it explicitly, but the purpose would be to have some sort of paper trail that can be shown to family court, can be shown to SPS, that the contact is for the purposes of the children, and obviously what we have here is something that's beyond that. I look at this akin as to a stay out of trouble violation. There's not something that we can do to keep this defendant from staying out of trouble or from contacting this person unnecessarily. There's not a patch we can put on. There's not an ankle device we can put on. Really, the only thing we can do is to put this person in custody pending the trial and basically say, hey, look, you can't have contact with this person, and if they do, it'll be recorded on the phones in the jail. And, that's really the only thing we can do to protect this person. I would note that we have someone from the police department here. We have a victim advocate. Her name is Dodie Rohr. She is present. She's been here all day waiting for this case to be called, but she represents that she's had contact with the named victim in this case, and just is here to see the outcome of the case.
Okay. And who's here from the police department?
Dodie Rohr. She's in the back, Your Honor.
Oh, okay. All right. Same person then, correct?
The one I just mentioned.
All right. All right, very good. Mr. Draskovich?
Let's start just with the basics concerning this no contact order. In the violation, it claims that he was told on November 7th to have no contact. We appeared via fax. It was a fax arraignment.
Right. Okay. I have the conditions of release order in front of me,
And when was,
November 7th. And I think that's where it may be coming from, but I assume that,
I don't know. I mean, he doesn't know. I'd asked him to provide me with any orders that he got from the court, and he kind of looked at me kind of dumbstruck. So, I mean, first of all, it's not like he stood in court with me and was ordered to have no contact, number one. There's a custody dispute going on. There's a divorce. I don't have a no contact. I see in an attachment there's a no contact order apparently on the 7th, but that didn't happen.
so I show that he spent 13 hours in custody back October 10th, and bond was posted October 10th. And that's when I would expect that he signed a condition of release, would be October 10th. Correct me if I'm wrong, City.
Judge, I show that the conditions of release was signed on November 7th. Here's a copy of that.
Correct. What? Yeah,
That's fine.
actually, this looks like the original.
We had no court appearance that day, though. It was, like I said, it was an initial arraignment by a fax.
I show, right, the EATS program, that electronic.
And just in all candor to the court, I have a note from November 7th that shows via EATS, which is the electronic arraignment, defendant present, not guilty. Judge ordered a no contact with victim at city's request. So I am showing that the defendant was present.
And my client's informing me that he wasn't. I wasn't. We just sent in a fax.
Judge, and if I may, if for some reason he wasn't present, I'm going back. Sorry, I'm trying to go back and see if he was present or not. I don't show that he was present, but if that being the case, if he was not present, we would send out the copy of the conditions of release by mail.
Court's indulgence.
And I don't know if defendant wants to clarify the mailing address, if it's correct to our records, but.
And Mr. Rainey was the deputy here today, and so I misrepresented. I read this as defendant present, not guilty. He says defendant pled not guilty, so I retract my statement. It doesn't sound like he was present on November 7th.
Right. Well, what happened on October 10th when he was released in custody, though? They don't make him sign a conditions of release at that time? That's when I thought they did.
Judge, at that particular time when he was arrested, we did not, we were not instructed to do a conditions of release. It was not requested.
Okay, so on November 7th, when the arraignment occurred, the judge signed this. How's the defendant get it?
We mail it. So if the defendant's not present, we will go ahead and mail him the carbon copy of the conditions of release. And like I said, I'm not entirely sure if defendant wants to clarify the address to make sure that our records are correct, but we do mail a copy of the conditions of release if they're not present.
I see the problem now. He's out of his home. They're originally on TPO. They mailed this to her. He has no access to his mail. He never got this order to have no contact, number one.
But it seems like he probably was subject to a condition of that, probably in family court.
Which I have a recording from the judge, is Judge Ducksworth, and if you want to watch, telling him that they need to sit down and talk about this case. It's not going to be resolved in courtroom.
That was January 3rd.
And you're
So he was actually following the judge's instructions when this phone call occurred. And I have it if Your Honor wants to watch it. He says, you two need to sit down and discuss, and he's talking to my client.
May we approach, Your Honor?
Sure, let's.
Off the record. Back on the record.
All right, sir. Sir, do you understand what the problem is?
Yes.
I think you would concede. I'm reading these text messages, and they don't all talk about the children.
So just briefly, you can see what's happening here is the criminal court is doing everything in its power to protect the victim. Some people might think it's just a harassment issue, but what it actually is is it's the defendant in a criminal case trying to dissuade a witness from testifying against them. In this particular situation, apparently the defendant is trying to get back together with her, so he says, and I'll run some of these text messages that I've received when I do a more in-depth analysis later on. But what's going on is certain family court judges simply do not understand the point of the no contact order. They think they know better, or they're just ignorant as to it. And what they don't realize is that the criminal defendants with family court cases basically use the children and the family court judge as a way to try to dissuade the witness from testifying against them. Again, I'll talk about this more in depth a lot later, and I'll explain how I've seen patterns of this over and over again, and certain family court judges just having no clue what's going on.
So, but there is some conversation about an oculus. So at this time, the court is going to advise you that you don't have no contact with the victim in this case that's alleged in the criminal complaint. How do you say the last name? All right, you have no contact with him. The only contact you need to make is about the children and pursuant to the family court. So in that, my understanding is that she wishes only communication via text. So that's how I suggest you communicate with her, and no other communication about your relationship, just about the children. That's it.
I understood that. I would have done that exactly like that.
Okay. All right.
Thank you.
Thank you, counsel.
Trial date stands, jury trial date stands, March 21st, 2023 at 9 a.m., Department 3.
Thank you.